law, SB 327, applied to meal period waivers for healthcare employees. There was a case that came out early in 2013, the Gerard versus Orange Coast Memorial Medical Center, that ruled that this waiver found in a wage order that applied to healthcare employees, and it's a waiver that only applied to them for healthcare employees, that said that they could waive their meal break. And it was right in the wage order. The court said that those waivers were not effective under the law, and this was a huge surprise to everybody in the employment industry litigating these cases in the healthcare industry, because it's right in the wage order. So it was an anomaly. The legislature actually passed this law to say no, what the wage order says is the law, so that medical care providers can waive their meal breaks. Now, I know I probably don't have a lot of medical care providers on the call, so why do I bring this up? But it's something every employer could learn from. First, know what rules apply to your industry and what wage orders apply to your industry. Certain wage orders, for example, the healthcare employees have certain meal and rest break provisions that don't apply to other industries. So, for example, meal period waivers are not permitted in certain industries, such as the restaurant industry. And the employers just need to know what laws apply. And generally, I get this question all the time, well, can't employees waive the meal breaks? And what is that? For most industries, a meal period waiver is only allowed if the employee's shift will end at 6 hours. And so they can waive it if it's under 6 hours. If they're working more than 6 hours, the Brinker case held that they can work through their meal break, but I am advising all of my clients to have their employees clock out and take that 30-minute meal break, so that you're not defending a claim after the fact when the employees now say that they were too busy to take a meal break. Your records show that they didn't take a meal break, and you don't have any evidence to dispute that fact. So I recommend that everybody just have their employees clock out before the end of the 5th hour and take that 30-minute meal break. And again, on-duty meal period agreements, I get questions about that sometimes. Very difficult to uphold, and generally non-enforceable in a lot of industries. For example, the restaurant industry. You really need to get employees to clock out, take the 30 minutes, leave the premise, and go do their own personal business for 30 minutes, take a break. And it's also important for employers to understand the timing requirements for meal and rest breaks. I put up a slide here, and again, this is a bit of a review going back to the Brinker case that came out from the California Supreme Court a few years ago. But again, it's just a good review for employers to take a look at this and make sure that you're getting the employees to clock out before the end of the 5th hour. So if they start at 8 a.m., they're clocking out before 12:59 and taking the 30-minute meal break. And again, just review, before I get to rest breaks, this meal breaks, there is an opportunity that employers can provide an early lunch to employees so that you don't run up against the timing requirement to have them clock out before the end of the 5th hour. Brinker did say in certain circumstances, employers could have the employee clock out early for their meal break, so that their obligation to give the meal break is provided early. And this comes up a lot in restaurants. So the employees come in, do some prep work, clock out for their 30-minute meal break, and then work during the rush. So that is an option to kind of keep in mind going forward. For rest breaks, to remember the requirement, and Brinker clarified this for us a lot. And again, it's something employers should just double check their rest break policy, that it's not every 4 hours you get a 10-minute rest break. It's at every 4 hours or major fraction thereof, the employees get a 10-minute rest break. So basically at the 6th hour, they get a second 10-minute rest break, because that's the second part of their day. So this timing requirement should be reviewed. Make sure the policies are up to date. Rest breaks, just a quick overview again, just need to be authorized and permitted, and can still require the employee to stay on the premise for a rest break, unlike meal breaks. Some case law development in 2015, an employer should also understand and should probably implement a policy here that if you do have employees that miss a meal break or forget to clock out, go ahead and pay out the extra hour of pay of that employee's rate of pay for a meal break premium for any violations, or even if the employee just mistakenly doesn't clock out. This will give you a defense that you've got a process in place to deal with violations, and that you do treat violations seriously, and that there is a trigger, a mechanism to pay out employees this extra hour of premium pay that is due if they missed a meal or rest break. This case, Safeway versus Superior Court, said basically because the employer didn't have a policy of paying out that premium pay, excuse me, that just even though they had a compliant meal and rest break policy, because they didn't pay out that premium pay, that issue could be certified as a class issue, and the class action could proceed on that theory that the company was not paying out the premium pay when there was a missed meal or rest break, could be certified as a class action and proceed as that. Now, they have defenses. The company has a defense to that in continuing the litigation. Just because the class is certified doesn't mean they lose that issue, but it was an issue that court said could be certified for class action purposes.